This class will give some of the constitutional law background necessary to understand the law of US democracy. And so I'll just begin by sort of putting out there some of the traditional canons of constitutional interpretation, and then we'll apply them to the right to vote and the applicable constitutional language. And so when interpreting the Constitution, there are sort of several different modalities that judges engage in. The first is always to look at the text and see what the words of the Constitution say. Secondly, look at the structure and relationship of the different provisions to each other. Then maybe look at the original meaning, the original intent of the provisions of the Constitution. What did the words mean at the time of the framing or at the time of the given amendment? Then look at the history of that particular phrase in the Constitution. How has it been interpreted and applied over time? And that includes, of course, the precedent and doctrine. And so the history would include not just judicial precedents, but also how political actors over time have applied that provision. But the precedent and doctrine could be consistent with the original meaning, or it could be contrary to it. And so paying attention to the precedent and doctrine is its own modality of constitutional interpretation. And then finally, there are a series of sort of prudential or ethical or policy arguments that often make their way into the constitutional law of elections. We'll pay attention to two in particular. The first is the idea of protecting discrete and insular minorities. The second is what we call representation reinforcement, or clearing the channels of political change. Sometimes we'll call these the Caroline Products footnote 4 justifications, named after a famous Supreme Court case, or maybe the John Hart Ely factors, which coming out of his book, Democracy and Distrust. But those are sort of typical policy arguments that are often made, or ethical arguments to justify greater judicial intervention when it comes to voting rights. As mentioned in the previous lecture, most of the judicial action under the Constitution with respect to voting rights has occurred under the mandate of the Equal Protection Clause of the 14th Amendment. And remember that those words say that no state shall deny to any person within its jurisdiction the equal protection of the laws. And so the words themselves, they don't say anything about voting rights compared to, say, like the 15th and the 19th Amendment. And so to understand how the Equal Protection Clause works when it comes to the law of democracy, you need to understand sort of two strains of cases. The first is what we call suspect classification cases. The second are the fundamental rights or fundamental interest prong of equal protection. So when it comes to suspect classification, this is sort of most of equal protection law. We think of a law as discriminating on the basis of, say, race or gender or another protected characteristic. And then we subject that law to what we call strict scrutiny. And ordinarily, something like a racial classification is going to be struck down as not well tailored to serve a government interest. And so you can think of all the famous cases, whether it's Brown versus Board of Education or any number of race discrimination cases following it, where the Supreme Court and lower courts would strike down something as violating the suspect classification prong of equal protection. Critically, in order to violate that part of the Equal Protection Clause, or that strand of cases, the discrimination against the protected class has to be purposeful, right? So you must have discriminatory purpose and discriminatory effect, meaning that the discrimination must be because of, not merely in spite of, the victim's protected characteristic. And that comes from a Supreme Court case called Personnel Administrator versus Feeney. And so it's not enough that a particular law have a racially discriminatory impact or a gender-specific impact. It must be intentionally discriminatory. And that makes it sometimes very difficult to prove racial discrimination, because while the effects might be easy to discern, trying to prove that the legislator or the government actor had discriminatory purpose is sometimes quite difficult. Most of voting rights law, though, is not under the suspect classification prong of equal protection. It's under what's known as the fundamental interest prong of equal protection. And this is more complicated because when you sort of adjudicate a case or discover a right in the Equal Protection Clause outside of the suspect classification prong, what you're saying is that it's not that the Constitution guarantees this right. You're saying that if a state gives that right to some people, they have to give it to others on equal terms. And so there are very few rights that are sort of inserted or read into the Equal Protection Clause in the same way. The right to vote is the most sort of notorious or famous when it comes to the Equal Protection Clause's fundamental interest prong. But we also have cases that deal with the right of access to courts under this view, and even the right to marry sometimes, although there's the right to marry is also viewed in the Due Process Clause. Most unenumerated rights in the Constitution, when you think of things like right of contraception, right of privacy, are not read into the Equal Protection Clause. Rather, it's only these rights which require the government to do something which are read into that. And so, what makes, for example, voting rights, the right to access to courts, and even the right to marry sort of similar? It's not that the government is just being prevented from infringing your rights in the same way that it would infringe on, say, speech or religion. It requires the government to do something. For voting, it requires the government to set up elections. For access to courts, it has to sort of set up the court system first in order to protect that right. For marriage, right, it's not like marriage exists in a vacuum. The right to marry is something that's guaranteed by the state. And so whenever the state grants some people these rights, they have to grant it to others on equal terms. And that's the way we think about the fundamental right to vote under the Equal Protection Clause. If a state has violated the rights of a person under the Equal Protection Clause, what is the analysis that a court would go through? And in order to sort of understand the vocabulary of that the Supreme Court uses in these equal protection cases, it's important to understand the tiers of scrutiny. And so I don't want to overstate the clarity by which the Supreme Court has come up with these tiers of scrutiny. Just think of it as a kind of language that we use in order to decide whether a law is presumptively unconstitutional or constitutional. And so there are generally three categories of scrutiny, going from strict scrutiny to intermediate scrutiny to rationality review. Depending on who you ask or looking at a particular case, sometimes people will say, oh, well, this is strict scrutiny minus, this is intermediate scrutiny plus, this is minimal rationality review, as opposed to rationality review with bite. And so those sort of categories, I think, are for another constitutional law class. But just to understand what we mean when we talk about these levels of scrutiny, I just wanted to focus on the state interest that is asserted, and then also the means ends fit for the law. So that, for example, if you have a law that is a racial classification, intentionally discriminatory on grounds of race, or is violating the voting rights of people in the state, that law will require a compelling state interest, and that the means are narrowly tailored to achieve that compelling interest, right? And so that's the highest level of scrutiny, and it's very rare that a law, once strict scrutiny is applied, will survive that kind of judicial analysis. And so, a compelling state interest could be something like national security, or safety, or even protecting the integrity of the ballot or democracy. But is the racial classification or is the violation of voting rights necessary or the least restrictive means in order to achieve that compelling state interest? Rarely is it going to be needed in order to achieve that compelling state interest. And that's why one of my former colleagues at Stanford, Gerald Gunther, would often say that strict scrutiny is strict in theory, but fatal in fact. And so as we go through the case law dealing with the law of democracy, you'll see that once we decide, if the court decides that strict scrutiny applies, that often means that the given law will be struck down. Lower levels of scrutiny are intermediate scrutiny and rationality review. Intermediate scrutiny applies to, for example, gender discrimination, where the state interest must be important and the means ends fit must be substantially related to achieve it. But most laws are subject to what's known as rationality review, that the state interest need only be legitimate and that the means ends fit must be rationally related. So all sort of non-fundamental rights, non-suspect classifications receive rationality review as their level of scrutiny, and almost always that means that the law will be upheld. Now let's talk about the right to vote with respect to the canons of constitutional interpretation that I mentioned before. So, first, if we look at the text explicitly gives power to define the franchise to the state legislatures. And indeed, it's because there is no right to vote that's guaranteed in the Constitution that we've had to amend the Constitution with the 15th, 19th, 24th, 26th Amendments in order to prevent discrimination with respect to the right to vote. So that if there was, either in the 14th Amendment or in the original text of the Constitution, a guarantee of a right to vote, you wouldn't have to amend the Constitution in order to prevent discrimination with respect to the right to vote. Secondly, if we look at the original intent or the original meaning of the Constitution with respect to voting rights, we know that at the time of the founding, there was no sense that everyone had a right to vote, because at the time, it was only white male property owners who, in most states, were given the right to vote. And as mentioned before, that is why we needed the amendments to the Constitution to have broader enfranchisement of racial minorities and women. Third, let's look at the history. Well, there's no sort of nationwide universal suffrage at any time until the court starts mandating it in the 1960s. And so whether you look at the period before the Civil War, where white male property owners were only allowed to vote, or the slow enfranchisement of different groups afterwards, whether with respect to race and gender, and then of course the long period between the 14th and 15th Amendment through Jim Crow up until the 1960s, there was certainly sort of no widespread guarantee of the right to vote, particularly of African Americans in the South. And so the history, if we look to it, does not sort of look particularly pretty in terms of guaranteeing the right to vote under the Constitution. And then if we look at precedent, it's really not until the 60s, although there are some notable exceptions, but it's not until the 1960s where we start getting precedent, particularly from the Supreme Court, guaranteeing the right to vote, and also guaranteeing one person, one vote, which we'll discuss in the redistricting cases. And why is it that we haven't seen judicial protection of the right to vote or constitutional interpretation of the right to vote until well over a century and a half of U.S. history? A lot of this is fear by judges of getting involved in politics, or at least that's what's expressed in a lot of these opinions, fear of what's known as the political thicket, to quote a Supreme Court case, Coldgrove versus Green. And also, the difficulty of the court being able to enforce a lot of its judgments. And so there's concern that if the court were to get involved in politics, that it would be very difficult for them to force a state to enfranchise parts of its population. Of course, in the 1960s, where the Warren Court becomes a lot more sort of bold in protecting voting rights, those reasons for abstention go out the window. But up until that time, there was real concern on the part of the court about getting involved in politics and of directing states to protect the right to vote. The area of voting rights, however, is often seen as the best case for judicial intervention based on what I described before as the Caroline Products footnote 4 rationales. And as we think about this, sort of one way to consider it is that, what is it about the right to vote that makes it different than other kinds of rights that are not explicitly mentioned in the Constitution? So why should sort of black robe judges sitting in a marble building in Washington overturn the political process when it comes to regulation of elections and voting? Because that's a very significant thing for them to do. And we know from the sort of controversies in the 1930s with the Lochner Court that there are real costs to judicial intervention. In that case, it was about striking down laws under the right to contract and other economic rights. And so there was a fear that judges would go in and strike down laws that were popularly supported. So what makes the right to vote different than the right to contract or other kinds of rights in the political process that are not necessarily specified in the Constitution? And so remember, the rationales that are known as the Caroline Products footnote 4 rationales are the protection of discrete and insular minorities and the clearing of the channels of political change, or what we call representation reinforcement. And so as we sort of think about these particular rationales for protecting voting rights, it's important to understand that what the court is doing when it acts in service of those rationales is trying to remedy a defect in the political process. And so if majorities are systematically ganging up on minorities and enacting legislation or depriving them of their rights without their consent, that is a good argument for judicial intervention. Now, it's not as if all discrimination against minorities or all majoritarian legislation somehow calls out for judicial intervention. It's really discrete and insular minorities, minorities that are sort of systematically discriminated against, historically discriminated against, who are sort of powerless in the political process, that require or call out for judicial intervention in order to get protected, particularly when it comes to voting rights. The second, though, rationale under the Caroline Products footnote 4 is equally important, and it comes up in the right to vote cases. It comes up in the one person one vote cases. It even comes up in the political party cases or the campaign finance cases. And this is the idea that when it comes to regulation of the political process, judges should be particularly suspicious of incumbent politicians. And the idea here is that we shouldn't let the fox guard the hen house, right? And it is those black robed lifetime appointed judges who are actually in the best position to regulate the political process and to prevent self-dealing on the part of incumbents. And so, for example, when it comes to one person, one vote, the districts in the United States up until the 1960s in many states had wildly different populations in them. So in a given state, you could have one state Senate district which had 100 times more people than another state Senate district. But the incumbents from those districts never had an incentive to overturn the districts that elected them. And so this representation reinforcement argument is about judges going in and trying to rectify some defect in the political process that prevents the democracy from working. And it's only because they are sort of unelected and appointed for life that they're going to be able to provide that check on the political process. Now, I should say that there's sort of a theory underlying these rationales. It's not clear that you need to have either a written constitution or judicial review of this type in order to protect minorities or to ensure that the democratic process is protected through representation reinforcement. You look at other countries like Britain and others which might not have a written constitution or might not have the strong form of judicial review that we have in the U.S., and it's not as if voting rights are systematically unprotected there. But in looking at the rationales for constitutional interpretation and the unique reasons that judges should be involved when it comes to voting rights, the protection of minorities and representation reinforcement are two of the most powerful arguments. Judicial intervention under these rationales of protecting discrete and insular minorities or clearing the channels of political change is an example of judicial activism. And by that, we mean that judges are going in and striking down legislation that is popularly supported. But the argument that's brought forward in Caroline Products and in Democracy and Distrust is that these are the best examples of judicial activism and intervention. It's sort of judicial activism on the side of protecting the political process and protecting the democracy. And so as we look at the voting rights cases that follow, we'll see examples where the court says, look, yes, we know that the original intent of the Constitution or the framers of the Constitution was not to expand the right to vote, but that the Equal Protection Clause is not shackled to the political theory of a particular era. Those are the words of the Supreme Court in Harper versus Virginia Board of Elections, which struck down the poll tax and became the foundational case for protecting the right to vote.